The Senate will come to order. Order business number 4, reports of committee.
Madam President, your Committee on Revenue and Economic Development, to which was referred Assembly Bill Number 9, has the same under consideration. Basic report, same back recommendation, do pass. Signed, Senator Dina Neal, Chair. End of reports.
Thank you. Order business number 10, introduction, first reading, and reference.
Senate Bill Number 364, introduced by Senator Scheibel, revises provisions relating to emergency medical care for a victim of sexual assault or attempted sexual assault. End of bill.
Thank you, Senator Scheibel.
I move that this bill be referred to the Committee on Education. Nope. To the Committee on Health and Human Services. Excuse me.
Thank you, Senator Scheibel. Has referred Senate Bill 364 to the Committee on Health and Human Services. Any objections to the referral? If not, so ordered.
The next two bills will be read and referred together as they are from the same committee and going to the same committee. Senate Bill Number 365, introduced by Senate Committee on Judiciary, requires the implementation of a pilot program relating to the housing of certain youthful offenders. And Senate Bill Number 366, introduced by Senate Committee on Judiciary, revises provisions relating to juvenile competency. End of bills.
Thank you, Senator Scheibel.
And I would move that both of these be referred to your Committee on Judiciary.
Thank
please.
you, Senator Scheibel. Has removed Senate Bill 365 and Senate Bill 366 to the Committee on Judiciary. Are there any objections to the referral? Not so ordered.
Senate Bill Number 367, introduced by Senate Committee on Revenue and Economic Development, removes certain exemptions from the excise tax on live entertainment. End of bill.
Thank you, Senator Neal.
Thank you, Madam President. I refer SB 367 to Committee on Revenue and Economic Development.
Thank you, Senator Neal. Has referred Senate Bill 367 to the Committee on Revenue and Economic Development. Any objections to the referral? If not, so ordered.
Senate Bill Number 368, introduced by Senate Committee on Government Affairs, requires the issuance of bonds for environmental improvement projects in the Lake Tahoe Basin. End of bill.
Thank you, Senator Dondero-Lupe.
Thank you, Madam President. I move Senate Bill 368 be referred to your Committee on Government Affairs.
Thank you, Senator Dondero-Lupe. Has referred Senate Bill 368 to the Committee on Government Affairs. Are there any objections to the referral? If not, so ordered.
Senate Bill Number 369, introduced by Senate Committee on Judiciary, revises provisions relating to criminal procedure. End of bill.
Thank you, Senator Scheibel.
I move that Senate Bill 369 be referred to your Committee on Judiciary, please.
Thank you, Senator Scheibel. Has referred Senate Bill 369 to Committee on Judiciary. Any objections to the referral? If not, so ordered.
Senate Bill Number 370, introduced by Senate Committee on Natural Resources, revises provisions relating to food policy. End of bill.
Thank you, Senator Doniate.
Thank you, Madam President. I move Senate Bill 370 to the Committee on Natural Resources.
Thank you, Senator Doniate. Has moved Senate Bill 370 to the Committee on Natural Resources. Are there any objections to the referral? If not, so ordered.
And that concludes order of business number 10 on the agenda. Prior to joint session, we will have an introductions order of business 10 when we get out of joint session this evening.
Thank you. Let's take a brief recess.
The assembly will come back to order. The chief clerk of the assembly will call the assembly roll.
Assemblywoman Anderson. Assemblywoman Benitez Thompson. Assemblywoman Vilbray Axelrod. Assemblywoman Black. Assemblywoman Brown May. Assemblywoman Carlton. Assemblywoman Cohen. Assemblywoman Considine. Assemblywoman Dickman. Assemblywoman Duran. Assemblyman Ellison. Assemblyman Flores. Assemblywoman Gonzalez. Assemblywoman Gorlo.
The Senate will come back into session. Thank you. Madam Secretary, will you please call the roll?
Senator Brooks, Senator Buck, Senator Canizaro, Senator Dennis, Senator Doñate, Senator Dondero Loop, Senator Goicoechea, Senator Hammond, Senator Hansen, Senator Hardy, Senator Harris, Senator Kieckeffer, Senator Lang, Senator Neal, Senator Orenshaw, Senator Pickard, Senator Ratty, Senator Scheibel, Senator Severs-Gansert, Senator Settlemeyer, Senator Spearman.
We'll have another brief recess. We're going back into joint session, guys.
Assemblywoman Howdigy will escort Chief Justice Hardesty to the Chief Clerk's rostrum. Everyone please rise. Chief Justice Hardesty, we welcome you and look forward to your message.
Thank you so much for your extraordinarily kind reception. I really appreciate it, and I know my colleagues on the court do as well. With permission from your leadership, I was able to remove my mask. I think my wife was happier about that than anybody. Governor Sisolak, Speaker Frierson, Majority Leader Canizero, Minority Leader Titus, Senator Settlemyre, distinguished members of the Senate and Assembly, honorable constitutional officers, I thank you for the opportunity to speak to the 81st session of the Nevada Legislature on behalf of our state's judicial system. My purpose this evening is to update you on certain matters affecting the judicial branch of Nevada's government. But before I do, I want to say on behalf of Nevada's legal system that we offer our heartfelt condolences to all those who lost loved ones and suffered other hardships during the pandemic. We sincerely thank all of the healthcare workers and frontline responders who have worked tirelessly to keep us safe. And on behalf of the legal system, we would like to take this opportunity to thank Governor Sisolak and his staff for their work in early January to add the judiciary and its court staff and members of the Nevada legal system to the frontline priority lanes for vaccinations against this terrible disease. By January 11th, we successfully developed a priority plan for the judicial system and transmitted to the State Health Department the names and contact information for 2,274 state and federal judges, seniors, magistrates, masters, DAs, public defenders, U.S. attorneys, and other staff seeking vaccination. And by January 22nd, we conveyed to the state a priority plan and names for the vaccination of 6,544 non-government attorneys and their staff, all of whom were engaged in frontline activities and exposed to the virus. Many thanks go out to Supreme Court HR Director McKenna McCormick and staff member Vicki Elefante for the time they spent in compiling the judiciary and staff lists. And I'd also like to recognize Kim Farmer, Executive Director of the Nevada State Bar, for coordinating the outreach and compilation of the list of attorneys and their staff. You might be interested to know that in a recent survey of the Nevada Appellate Court employees, 74% of those seeking vaccination will be fully vaccinated by May 1st. The success of the vaccination effort for the courts and the legal system will make a big difference in our decision to open the courts around the state. Since 1981, our country has commemorated women's history. In this, we take time to reflect on the advances women have made over the past decade or two. I thought it would be interesting to recall that two remarkable women were born on this day in history. Gloria Steinem, March 25th, 1934, and Aretha Franklin, March 25th, 1942. I submit it is notable also that Ruth Bader Ginsburg was born on March 15th, 1933. What an appropriate month to celebrate the advancement of women in our country. And without a doubt, all three of these women were leaders in the cause of equal rights for women. Nevada has a lot to celebrate as we recognize the advancement of women in critical positions of public service in our state. As examples, as we know, women hold a majority of the seats in our legislature and serve in both Nevada's seats in the United States Senate. But I'd like to comment about the historical achievements of women in the transformation of the makeup of Nevada's judiciary. Since Miriam Schering became the first woman elected to the district court in Nevada in 1982, the legislature has increased the number of district court judges to 90. Following the elections this past November, 56 of those 90 judges are women. And in 1992, Justice Schering was elected the first female justice to serve on the Nevada Supreme Court. And in 2019, Nevada made history when, as a result of the November 2018 elections, a majority of the justices serving on the Nevada Supreme Court today are women. I submit the advancement of women in a traditionally male-dominated part of the legal profession deserves recognition, especially during Women's History Month. I'd like to introduce my friends and colleagues on the Nevada Supreme Court. They're not here tonight. They wish they could be. They promised me they'd be watching, and they better be. Associate Chief Justice Ron Paragary, Justice Lydia Stiglich, Justice Alyssa Kadish, Justice Abby Silver, Justice Christina Pickering, and the most recently elected Justice Douglas Herndon. I'd also like to recognize our colleagues on the Nevada Court of Appeals, Chief Judge Michael Gibbons, Judge Jerome Tao, and Judge Bonnie Beulah. It is my privilege to serve with all of these distinguished jurists, and I'd like to publicly thank them for their support during my service as Chief Justice. All of us offer our special thank you to the Clerk of the Court, Elizabeth Brown, the Assistant Clerk of the Court of Appeals, Kurt Jensen, the Chief Legal Counsel, Phaedra Kalicki, the Reporter of Decisions, Kim Edwards, the recently appointed State Court Administrator, Catherine Stocks, and the dedicated, hardworking staff of the Nevada Appellate Courts and Administrative Office of the Courts. As many of you may recall, Robin Sweet recently retired as the Director of the AOC, and we'd like to thank and recognize Robin for her dedication and years of service to the Supreme Court and to the people of the state of Nevada. Tonight, it is my privilege to speak on behalf of the justices, the 3 Court of Appeals judges, the 90 District Court judges, the 67 justices of the peace, the 30 municipal court judges, and over 2,000 court employees throughout our state. Nevada's judicial officers and court employees are committed to the administration of fair and impartial justice according to the rule of law in criminal, civil, family, and juvenile matters. In fulfilling our constitutional and statutory duties, we are mindful of the importance of providing timely access to the court system and resolving cases as efficiently as budgets and caseloads will permit. As Chief Justice, I offer my profound thanks to all of these public servants and their staffs for their service to all Nevadans. And on their behalf, I am proud to report to you tonight on several matters of interest to the judicial branch of state government. Let me begin. On November 2014, the voters amended the Nevada Constitution, adding a Court of Appeals to our state's appellate system. Since its inception in January 2015 and through December 2020, the parties have filed 15,119 cases with the Supreme Court of Nevada. And that court and the Court of Appeals have collectively resolved 16,202 cases, significantly reducing our backlog while also publishing 570 opinions on Nevada law. Through this 6-year period, the budget supporting the Court of Appeals has remained substantially as predicted in 2014. and we are all proud of the public-private partnership that brought a beautiful, nationally recognized courthouse to downtown Las Vegas, while saving the taxpayers thousands of dollars in annual rent. All in all, a successful business plan. The pandemic has forced all of us to face challenges that we could never have imagined a year ago. While the pandemic brought our society to a halt, the disputes resolved by the court system did not go on lockdown. Indeed, some cases, such as domestic violence, sexual exploitation, families in crisis, or substance abuse, have likely intensified. Courts, as you know, are traditionally places where many people, sometimes hundreds, come together in person. In-person visits to the courthouses around the state to participate in jury service, pay parking tickets, seek restraining orders, resolve landlord-tenant disputes, etc., became dangerous due to the potential exposure of the virus. Obviously, that could not continue. As the realities of the pandemic became clear, the judiciary shifted, where it could, to technology, to hold hearings remotely. I'd like to thank and recognize Chief Justice Pickering and Chief Judges Linda Bell, Scott Freeman, Susan Bauckham, Melissa Saragosa, Sam Bateman, and the many other judges around the state for their tireless leadership on so many issues that literally kept the courts operating this past year. And a very special thank you goes out to the incredible court administrators and IT staff for their innovations and creativity that allowed us to pivot the court systems to a virtual format in a matter of days. Shifting many in-court proceedings onto remote platforms may ultimately be one of the few bright spots to come out of the pandemic. Many lawyers and users of the public judicial system welcome the convenience of appearing remotely rather than taking the time needed to come to a brick-and-mortar courthouse. At Incline Village Justice Court, Judge Alan Tyrus implemented a virtual traffic calendar. With the exception of a few demands for in-person trials, the court is completely current despite a record year in case filings. And in the 8th Judicial District, the court IT staff moved quickly to develop custom software entitled Order in the Court, which enables attorneys and the public to submit proposed orders remotely and receive signed orders electronically. Since the software application was implemented court-wide in September, 105,930 orders have been processed. The district court has also developed electronic search warrants for both judges and law enforcement officers. The process has saved law enforcement at least 2 hours per warrant, and the court has processed 5,850 electronic warrants since April of 2020. In my judgment, remote hearings also promote transparency, as court proceedings are accessible in greater numbers of the public by video conferencing platforms. And it saves money. By way of example, the AOC Judicial Education Department collaborated with the specialty courts to host the first ever virtual statewide specialty courts conference. Over 200 attended each day, saving over $87,000 when compared to the previous year's in-person conference. However, this transformative shift to the use of remote platforms has highlighted several problems for the judiciary and the citizens we all serve. Not everyone has access to broadband services or sufficient broadband width or technology to connect to remote hearings. And sometimes participants in a remote court proceeding forget or disregard the decorum required for a court hearing. Just as an aside, it really isn't a good idea to call into a court hearing on your traffic violation while you're driving. Or in one case in Southern California you may have read about, while you're actually conducting surgery on your patient. Moreover, while e-filing is a preferable way to file documents with the court and reduce the number of people coming to the courthouses, Not all courts in Nevada have that capacity, and many do have systems that are far more cumbersome than originally imagined. I urge this legislature's support for the Supreme Court's one-shot request to begin implementation of the AOC statewide e-filing system for every court in Nevada. All that said, some of a court's work simply cannot be done remotely, most notably jury trials in criminal and civil cases. Jury trials were suspended at the beginning of the pandemic because they require the presence of too many people: jurors, parties, witnesses, attorneys, the judge, and staff. Limited spacing, close courtroom configurations, jury boxes, and aging courthouses have prevented most of the courts in our state from conducting jury trials. After the shutdown through February 1st of this year, almost a year, only 5 criminal trials and just 1 civil jury trial have been conducted in Clark County, and just 3 criminal jury trials in Washoe County. As a consequence, large backlogs of criminal and civil jury trials have developed around the state. For example, in Clark County, as of March 11, there were 252 capital murder cases, 1,386 felony cases, and 4,448 civil jury trials that are scheduled for trial in 2021. Particularly troubling currently are the 182 defendants in criminal cases in Clark County District Court who have invoked their constitutional right to a speedy trial within 60 days of their arraignment. In Washoe, 92 criminal cases and 186 civil cases are set for jury trials in 2021. In short, the 2 largest judicial districts in the state lack the capacity to conduct jury trials in a timely fashion, or even at all, as I'll explain. And the dockets will continue to grow. What many may not appreciate is the limitation on spacing in the courtrooms in our state sufficient to provide appropriate safety for all participants in the trials. Currently, Clark County District Courts have 2 courtrooms retrofitted to accommodate criminal jury trials, and 1 courtroom in the convention center to accommodate civil trials. But these venues are not near enough for the pending backlog. In Washoe County, while they retrofitted 2 courtrooms on the upper floors of the courthouse, repairs to 2 elevators that only transport 2 people at a time, over the next 8 months, servicing an aging courthouse will place severe limitations on that district's ability to conduct jury trials. In Elko, 6 jury trials have been conducted since September 2020. 3 in the convention center until it was no longer available to the court, 1 in the Stockman's Casino, 1 in the largest courtroom in the courthouse, and 1 in the county commission chambers. At this rate, I'm expecting to hear any day that the next trial will be conducted in a barn outside the city. And in Ely, a double defendant murder trial has been delayed over a year because there are insufficient funds to rent that city's convention center to conduct the trial. And in Winnemucca, Judge Montero, frustrated over the length of delay in a civil trial, personally took a saw to his jury box to create spacing so that the trial could proceed just last week. And the delays are not limited to the district courts. As an example, Sparks Justice Court is not able to conduct jury trials in 15 pending domestic violence cases because of the lack of proper spacing in their courtroom and jury box. And in Henderson Justice Court, it is in need of a jury box in courtroom 4 and advanced air quality systems in all their courtrooms to meet CDC guidelines. It is safe to say that the highest priority of the judicial system is to restart jury trials and begin clearing an escalating backlog. I have asked every judicial district in the state to submit a plan to create more venues, retrofit courtrooms, and provide safe facilities to conduct jury trials. In the coming days, I will present the statewide plan to the governor, and I request the opportunity to present it to you to restart jury trials and reduce backlogs. We respectfully request the opportunity to present these plans to the legislature, and we urge you to consider allocating some of the funds from the recently adopted American Rescue Plan to pay the costs that will be necessary to restore justice in our state. Improvements to existing venues, financial support to access larger venues, increased deployment of senior judges to every district will help create an environment to settle or try pending cases. As you all respect, the right to a jury trial is fundamental to our democracy. Regrettably, the pandemic has delayed access to that fundamental right, and we need to fix this now. Over the years, the responsibilities of the judicial branch have grown. Whether we like it or not, the state courts of this country are in the eye of the storm. We have become the emergency room for society's worst ailments: substance abuse, family violence, mental illness, residential evictions, and more. This reality has forced courts to approach cases with innovation and collaboration with all involved. I'd like to cite several instances or examples. In 2015, for example, the state faced an embarrassing number of cases of guardianship abuse. Following extensive study by the Supreme Court's Guardianship Reform Commission, the 79th legislative session approved numerous reforms to the adult and minor guardianship statutes. These measures included a protected person's Bill of Rights, the requirement for preliminary care plans and budgets in each case, and the appointment of legal counsel for proposed protected persons. In addition, AB 130 created the statewide Guardianship Compliance Office to assist district courts during the administration and oversight of the guardianship proceedings. Since then, the district courts have made substantial improvements to their data collection and case supervision processes. And the Compliance Office has audited estates worth a total of $95,892,800 and found approximately $9,107,773 worth of guardianship estate funds that were at risk of loss. Since March 2018, the office has established an 800 number hotline, has conducted 151 audits, 157 quality care investigations, 72 pre-guardianship investigations, and located 272 people who could not be found that were subject to guardianship proceedings. Further, the Supreme Court has adopted statewide rules and subsidized and standardized forms governing guardianship proceedings. And I submit that these measures, collectively, including your work, have resulted in the termination of guardianships that should have never been ordered in the first place, the avoidance of guardianships where least restrictive alternative means for protection were available, the location of people and assets subject to this system, and a system for investigations and accountability in guardianship cases. We thank you for your attention to this matter. Nevada's drug courts and other specialty courts continue the incredible journey that began in 1992 when Nevada launched the nation's 5th drug court in the country. It is a journey that saves lives, families, and futures of unborn babies. It is also a journey that reduces recidivism, playing a key role in the many reforms prescribed in AB 236 adopted in the 2019 legislature. The diversion of those suffering from substance abuse and mental health challenges will reduce the need for more jails and prisons. Nevada's statewide Specialty Court Funding Committee has launched 2 initiatives this year that I believe will provide additional accountability for these programs. First, a study of recidivism, and second, a peer review of sister courts. With the assistance of the Nevada Department of Health and Human Services biostatistician, I knew I was going to mess that word up, Department, an assessment of successful specialty court participants for 2017 showed the average recidivism rate to be 25%. In other words, consistent with national averages, 75% of successful graduates have not had a conviction since participation in their specialty court. We thank the legislature for your ongoing support of these courts. In addition, some judicial districts have initiated programs in partnership with local law enforcement to divert individuals away from the justice system to community-based services for treatment and life skills training. One such program is the new Law Enforcement Intervention for Mental Health and Addiction, under the acronym LIMA, in Clark County. LIMA is a 9 to 12 month pre-booking diversion program in which Las Vegas Metro redirects those with low-level drug-related charges into community-based services. From February 27, 2020 to March 5, 2021, LIMA has assisted 142 participants with transitional housing and other services ranging from employment to medical treatment. And none of those people ended up in the jails. In 2019, the Supreme Court commissioned the National Center for Juvenile Justice, the research division of the National Council of Juvenile and Family Court Judges, to assess the family court operation model adopted by the legislature in 1993. The goal of the assessment was to determine whether the family courts in Nevada are meeting legislative expectations and family expectations, following state and local court rules, and resolving legal disputes timely and effectively. After more than 10 months of interviews, detailed surveys, and on-site visits, the NCJJ released a 68-page report that can be found on the Supreme Court's website, concluding that the state should continue to sustain and support the coordinated family division model as originally conceived in the legislation 25 years earlier. It also made 7 recommendations. I'd like to highlight 3. First, and critically, both Clark and Washoe counties have outgrown the footprint of their facilities, and the urgency of the situation will continue to increase as the population and workloads increase. Outdated facilities in both of those jurisdictions are the most prominent threat to achieving the goals of coordinated family divisions. Second, both jurisdictions are operating with fewer judicial officer resources than all of the jurisdictions the researchers used to compare Clark and Washoe counties, with even after the addition of the judicial officers in 2021. Clark County would require over 7 additional positions, and Washoe County would require at least 4 to even begin approaching parity with comparable jurisdictions at the low end of the judicial source spectrum. And third, the NCJJ recommended that the establishment of an Office of Family Division Services within the AOC to improve family operating division goals, support judicial specialization, coordinate data and develop state-of-the-art training solutions to the one family, one judge case assignments. The pandemic has intercepted our court's progress on all of the recommendations, but I anticipate meaningful steps this year, planning for the implementation of the remaining recommendations concerning workload studies and the use of masters as an appropriate judicial officer in family court proceedings. When I addressed the legislature in 2015, I listed a number of items on the agenda for Nevada's judiciary. One included the subject of judicial education. At the time, we did not have an organized system for mandatory judicial education. I am pleased to report that the judicial education committees, with the support of the AOC, have developed mandatory education for every judge on numerous core legal and subject matters to be taken on a recurring basis. In addition, we support and agree with the need and inclusion of courses focusing on racial equality and implicit bias. Indeed, the district judges have already added an extensive program entitled the Red Door Project, which I had the privilege of participating in earlier this year with the Conference of Chief Justices, to their course list this May. Last November, as you may recall, the Nevadans amended the Nevada Constitution to reform the Pardons Board, increasing the number of required meetings to 4 per year. The measure was presented to the voters because of the incredible backlog of pending cases and the limited staff to investigate and present reports on applicants. Indeed, the board has but 1 staff member and over 240 cases in the queue to be investigated and presented to the Pardons Board. Regrettably, many of the agencies that support the work of the board had already submitted their budgets before the election, thus preventing them from including in their budgets the staffing necessary to support the reconfigured board. This week, the Pardons Board received presentations from the Nevada Department of Corrections, the Division of Parole and Probation, and the Parole Board concerning the budget requirements to support this new constitutional mandate. The board urges this legislature to include these enhancements in the agency budgets to help the board reduce these extraordinary backlogs as promised. The subject of residential evictions has been and continues to be a frustrating and vexing subject for all involved. The good news, more than 25,000 households and their landlords received assistance from the initial CARES Act Coronavirus Relief Fund. The second round of federal funding through the Emergency Rental Assistance Program, created by Congress in December, will add $161 million in funds in Clark County alone, and is projected to assist another 40,000 households. Millions in rent relief more are projected from the American Rescue Plan. One would think that with millions of dollars available in rent relief, the eviction issue wouldn't be so difficult. But it is far more complex than appears on the surface, believe me. Driven in large part by the time it takes to qualify tenants under the federal guidelines and connect them and their landlords to this resource. As recently reported, there are over 20,000 applications for rent relief pending in Clark County and 4,585 eviction cases in the Las Vegas Justice Court awaiting an eviction hearing, if the moratoriums are lifted next week. The number of applicants and cases threatens to overwhelm the system and the courts. Now, as you know, Home Means Nevada has operated an alternative dispute resolution program pursuant to rules adopted by the Supreme Court last fall. And I want to publicly thank Shannon Chambers, her team, and the many mediators who on very short notice stepped in to help parties resolve disputes concerning unpaid rent. With the status of eviction moratoriums unclear, it will be critical for all branches of state government to work closely together to find effective solutions for landlords and tenants over the coming weeks and months. The judiciary stands ready to work with all parties to implement case management plans that are consistent with statutory provisions you enact. As some of you may know, the Supreme Court recently entered an order creating a commission to study the adjudication of water law cases. The petition seeking this commission received broad support from throughout the state and provides a unique opportunity to thoroughly examine the adjudication of this vital public resource. I appointed this week the commission members, and our work will begin immediately. The commission's findings and recommendations are due April 1, 2022. I'm excited about the future of Nevada's judicial system, and I hope you will join with me in securing the right to a jury trial in our state as soon as possible and as soon as reasonably affordable. Our judges and court employees are enthusiastic. They're innovative and engaged, working every day to bring equal justice to all. But as Justice Breyer noted in his book, Making Our Democracy Work, we cannot take the public's confidence in the courts for granted, ever. I agree and believe that Nevada's courts will continue to earn the public's trust and confidence if we adhere to the rule of law, if we are proactive in the management of our cases, if we provide access to our courts, if we treat each person who appears before us with respect and dignity, if we are accountable in our behavior and our decisions, if we are fiscally responsible, and if we are transparent in all we do in the administration of justice. I want to thank you all sincerely for the honor of appearing before you this evening. Thank you.
Assemblywoman Nguyen.
Thank you, Mr. Speaker. I move that the Senate and Assembly in joint session extend a vote of thanks to Chief Justice Hardesty for his timely, able, and constructive message.
Assemblywoman Peters.
I second the motion.
You've heard the motion. All those in favor, please signify by saying aye. Aye. Opposed, nay. Motion carries. Assemblywoman Howdigy will escort the Chief Justice to the bar of the Assembly.
Thank you very much.
Assemblyman Hafen.
Thank you, Mr. Speaker. I move that the joint session of the Senate and the Assembly be dissolved.
You've heard the motion. All those in favor, please signify by saying aye. Aye. Opposed, nay. Motion carries. I declare the joint session dissolved.
The Senate will reconvene. Order of Business 9, Introduction of Resolutions.
Senate Concurrent Resolution Number 8, introduced by Senate Committee on Growth and Infrastructure, expresses support for the identification of key transportation priorities for the Lake Tahoe Basin. End of resolution.
Thank you, Senator Harris.
Thank you, Madam President. I move that Senate Concurrent Resolution 8 be referred to the Committee on Growth and Infrastructure.
Thank you, Senator Harris. Has moved for Senate Concurrent Resolution 8 to the Committee on Growth and Infrastructure. Are there any objections to the referral? If not, so ordered.
That concludes order of business number 9.
Thank you. Order of Business number 10. Where am I? Yeah, introduction, first reading, and reference.
Senate Bill number 371, introduced by Senate Committee on Growth and Infrastructure, revises provisions relating to motor vehicles. End of bill.
Thank you, Senator Harris.
Thank you, Madam President. I move that Senate Bill 371 be referred to the Committee on Growth and Infrastructure.
Thank you. Senator Harris has referred Senate Bill 371 to the Committee on Growth and Infrastructure. Are there any objections to the referral? If not, so ordered.
And that concludes order of business number 10 and business of the desk for this legislative day.
Thank you. Order of Business 16. Remarks from the floor. No guess. No remarks. Senator Cannizzaro.
Thank you, Madam President. Earlier today, we did hear that it is Greek Independence Day, so I move that in honor of our Greek brothers and sisters and their Independence Day, that we stand in adjournment until the hour of 11 a.m. on Friday, March 26, 2021.
Thank you. We are adjourning in honor of Greek Independence Day. So all those in favor signify by saying yay. Is there a Greek way to say yay? Any opposed? No. Motion passes. We're adjourned till tomorrow at 11, guys.